Ladies and gentlemen, our very special guest today was a Victorian Supreme Court judge for 21 years. Before being appointed to the bench, he was a Queen's Counsel for 10 years, Chairman of the Victorian Bar and Senior Vice President of the Australian Bar. He is Chair of the Victoria Law Foundation and has been a member of the Law School at Melbourne University for over 30 years. It is perhaps not surprising that he is also a member of Monash University's Medicine faculty, where he is conducting research into child abuse. After all, he did preside over the Daniel Valerio case, the 2-year-old boy whose death led to the introduction of laws requiring the mandatory reporting of child abuse. There were many other high-profile trials, including those accused and subsequently convicted of the murders of policemen Gary Silk and Rodney Miller in 1998, and the successful prosecution of Robert Arthur Selby Lowe for murdering 6-year-old Cherie Beasley 4 years earlier. Philip Cummins was still making headlines in his farewell speech earlier this year when he told a ceremony to mark his retirement that courts needed to increase sentences, particularly for violent and sexual offences, in order to better reflect community values. Courts, he argued, had failed to sufficiently secure the rights of victims, including in sentencing. I wonder what he thinks then of the various initiatives that have been unveiled since his departure. First, the government announced a Judicial Commission to monitor judges' behaviour as part of an anti-corruption regime. Then moves began to overhaul the way judges are appointed. They and magistrates could face physical and mental health checks before being appointed under a contentious government plan to modernise Victoria's judiciary. As The Age reported just 2 weeks ago, prospective judges may also be required to do extensive training, including role play and refresher courses throughout their career. The Attorney-General argues that to meet the demands of the 21st century justice system, the modern judge needs to have broader skills than the traditional attributes of high-level legal and technical skills. Is he right? Does Philip Cummins agree? We'll find out in a moment. Does he also believe suppression orders in Victoria are out of control and have been for a long time? Official figures show that up until last Tuesday, 1,524 suppression orders have been made since 2005. So far this year, that figure stands at 215. The gangland war and terrorism trials are responsible for many of them, although these figures also contain orders made in both the Children's and Coroner's Courts and the Bushfire Royal Commission, and comprise both active and revoked orders. Earlier this year, one of Melbourne's most experienced and respected media lawyers, Peter Bartlett, who's with us today, argued that many of these orders are also made until further order, meaning they stand indefinitely. Although he said these orders are in place to ensure that everybody receives a fair trial, there are some who might say the courts have been overzealous. Peter Bartlett went on, "Our legal system is based on the principle of open justice, that is, justice not only being done, but being seen to be done. In light of the myriad of suppression orders, the public is not being given adequate opportunity to see justice being done. Suppression orders," he concluded, "should only be made where absolutely necessary, and the court should be careful to set a finite duration." So who's right and who's wrong? And what does Philip Cummins make of it all? Why don't we ask him? Would you please make him welcome?
President, Vice President, good and old friends, and some good and new friends on table 10, years 11 and 12 of Kilvington Girls Grammar, whom I warmly welcome especially. The words are written on our hearts. Publicity is the very soul of justice. It is the keenest spur to exertion and the surest of all guards against improbity. It keeps the judge while trying under trial. Written in the 19th century by the legal philosopher Jeremy Bentham. And Franz Kafka, in Der Prozess, the trial in 1925, well understood it as a novelist might. He said of his protagonist, Joseph K. might care to remember that the proceedings were not public. They could be open to the public if the court thought this was necessary, but the law did not insist upon publicity. The mordant words of Franz Kafka. Well, we proclaim it often. Do we fulfil it? It's, I think, instructive to commence with an analytical matter, because although the courts plainly are committed to the principle of open justice and often proclaim it, embedded within the law are the seeds of the containment of that concept. And that seed is the judicial process itself. Lord Woolf said, "The need to be vigilant arises from the natural tendency for the general principle to be eroded and for exceptions to grow by accretion, as the exceptions are applied by analogy to existing cases." And Lord Shaw said, "There is no greater danger of usurpation than that which proceeds little by little under cover of rules of procedure and at the instance of judges themselves." So, what of our properly proclaimed principle of open justice? Plainly, there will be instances wherein the courts cannot responsibly be open or fully open, so much as recognised in our legislation, in interconnected criminal trials such as those occurring in Victoria over the last decade, in some terrorism trials, and in some cases of physical risk to life or safety of witnesses, orders can be justified. But the criterion in the Acts which govern us and in the common law is the criterion of necessity, not of prudence, not of advisability, a very strict and limited principle. Courts should be closed or publication prohibited only where it is necessary. So non-publication should never be a first resort and should only be a last resort. Well, given the powerful rationale of open justice and its frequent proclamation by the courts, it is salutary to examine what actually happens, as our President has said. If you look at the table now being put up, over the last 5 years in Victoria, this is the number of suppression orders that have been made. Salutary indeed. Why so many? I think there's 3 categories of reasons for the number of such orders. First and importantly, a number of orders are justified for the reasons I have stated: interconnecting trials, personal safety, and sometimes terrorism. Second, there has been a marked development in legislative provision found in court orders. The basal provision is the 1958 Judicial Proceedings Reports Act. Rightly, it prohibits the reporting of names of victims in sexual cases. It has some other limited prohibitions as well. But over the past 5 years again, the following relevant legislation has been enacted in Victoria. The purpose of many of these provisions is plainly beneficent and protects vulnerable persons. But a question arises about the 2009 Act, the last Act here, the Serious Sexual Offenders Act. The 2009 provisions effectively result in those cases proceeding in court and not being publishable. And this is a very serious matter. Certainly, reformation of offenders should be protected and facilitated. Reformation is in the interests both of offenders and of the community, and it should not be pushed aside. But ultimately, the community has a right to know the substance of proceedings in these matters. Correlatively, the media has a serious responsibility to exercise restraint in both the language used and in the quantum of publicity in this difficult area of reformation. There's two substrata which should be mentioned. The first is alternative dispute resolution, much promoted. Much of alternative dispute resolution occurs in private. If a judge is called upon to perform such a task, by way of pre-trial hearings or otherwise, I consider that it is inherent and necessary in the judicial function that that task be performed in public. This is a development which I think we all need to watch. The second development is legislative. The Court's Suppression and Non-Publication Orders Bill 2010, a proposed bill, is part of a national rationalisation of non-publication legislation. And by it, in addition to the grounds of necessity that I have stated, there is a further proposed ground for non-publication. And it is, quote, that it is otherwise necessary in the public interest for the order to be made, and the public interest significantly outweighs the public interest in open justice. I think that if that clause were enacted, there will be an escalation of suppression orders. We already have many on the grounds of necessity. How many more will we have on the grounds of the Janus-like principle of public interest? Mr. Justin Quill has written on this matter in the Legal Affairs section of The Australian on the 30th of July 2010, and I agree with Justin. Unfortunately, there is a further category of reasons, for the number of suppression orders presently made in Victoria, and that is that some of them are wrongly made. Some orders are made unnecessarily when legislation, notably the Judicial Proceedings Reports Act, governs the situation. Some orders are made unnecessarily when the common law principles of sub judice already govern the situation. This matter of sub judice is a matter of a special significance because it would be most retrograde if the principles of sub judice came to be supplanted by suppression orders. That is a cultural shift we need to be astute to. Sub judice has its proper place. We all need to know it, judges, lawyers and media alike, and it would be most retrograde if that principle, a living principle, shrunk and were replaced by suppression orders. Further, some suppression orders are made not on the grounds of necessity, the proper ground, but on the broader grounds, doubtless well-meaning, of therapy, prudence, being prophylactic, and that opens a vast area of suppression orders which, whilst well-meaning, are unjustified and which would make a significant erosion into the principle of open justice. Therapy and prudence are not the criteria. Necessity is the criterion for prohibition. And finally, you've heard me speak on this before, so I'll just say it and not develop it. Some orders are founded upon a lack of understanding of the integrity and discipline of the jury system. Trial experience shows that juries are well capable of acting solely on the evidence presented in the four walls of the court and of not being affected by the world outside, which is entitled to continue to exist while a trial is going on within its four walls. So, looking back at what Lord Woolf and Lord Shaw said, we need to be vigilant to ensure that little by little, under the cover of procedure at the instance of the judges themselves, suppression orders do not further extend and should be, in fact, constrained, and that they should not grow by accretion as the exceptions are applied by analogy to existing cases. A familiar judicial process, entirely justified analytically, but which is the seed of the growth which we do not want of suppression orders. Well, I'd like to be a little bit more positive and commend to you that the courts, in being open, ought to be more open by the electronic dissemination of court proceedings. As you know, today court proceedings routinely are recorded electronically. I think that recording should be publicly available. There is no reason why, in principle, the court should privilege one mode of dissemination over another. The information medium of much of the public is electronic. The requirement of accurate, fair and balanced reporting applies equally to electronic as to print media. The media, not the courts, should decide what is electronically newsworthy. It's not any part of the court's function, as presently occurs, to decide what part of a case is appropriate for electronic publication. The court should do the converse. As with print and other media, the court should only intervene where it is necessary to preclude publication, not where it might be considered desirable to promote it. And further, there is no reason why we should go down the American path. First, clearly there are cultural differences between Australia and America. And second, I think, and importantly, there is in Australia no First and Sixth Amendment, which has bred a lot of the publications in America. That jurisprudence does not apply to Australia. This would need to be worked through, and in particular, proper protection needs to be provided to victims and vulnerable persons. But that is a matter which can be worked through for the future. But I think if we do move to electronic dissemination, then more truly we might fulfil Jeremy Bentham's enunciation of publicity as the soul of justice. And finally, I would like to commend to you a good working relationship between the bench and the media. There is such, greatly assisted by Anne Stamford, who is here today, where the courts do welcome, and rightly so, the media and cooperate with the media in your essential function of being the window of the community to justice. Associates also can play an important part in being available to the media, in particular assisting the media in whether matters are going to occur during the day or in the next week which the media might want to attend or not attend. That's not promoting a case or promoting an individual, let alone a judge. It is simply treating the media with respect and decently, assisting the media in its daily work. Courts now have moved very substantially to typed sentences being available when sentences are orally pronounced, and typed reasons being available when judgments are orally pronounced. And I think that is a very helpful development by the courts, and I think the courts should be commended by that, for that. I would draw the line, however, at embargoing material to the media before it's denounced in court. It's not like the budget speech, and we are dealing with the lives of people, and I think it's appropriate to simply be ready when the event occurs in court. I was years ago on circuit in a country city in a very terrible murder and arson case, and there was a lot of local feeling about the matter, and the sentence was listed for 9:30 in the morning, and I was in court about 7, just working quietly away, and the staff was due at 9, and at 8 a.m. the phone commenced to ring, and it kept ringing and it kept ringing, so I thought perhaps I should answer it in case it was an emergency, and the same person was on the end each time, and she eventually asked me who I was, and I said, "This is the court," and I gave that answer a couple of times, and anyway, then I thought I perhaps might be misleading the person, so I said to her, "Who was she?" And she was the local media representative, and she said, "Who are you?" And I said, "Well, I'm the judge." And she said, "Oh, I'm very sorry, I'll ring back later." And I hung up, and 30 seconds later the phone rang again, and she said, "Judge," she said, "I won't say anything till 9:30, she said, "but can you just tell me what you're going to do?" So the Law Foundation gives legal reporting awards. Many of you here today have received them, and I commend all of you, but I think she should receive a special award for initiative. Michael.
Thank you, Philip. And Philip has very kindly agreed to answer some of your questions. There are a couple of roving mics, and if you could identify yourself and the organisation that you represent, that would be helpful. Also, I should just add at this point that Philip is unable to comment on any current cases before the court, or indeed in any detail about any of his cases. So if you could keep that in mind, that would also be very helpful. Who's going to kick us off? Karen, over here.
Philip, Karen Cassane from the Age newspaper. I was just wondering, with regard to your concerns about the suppression orders that you believe are legally unnecessary, what can be done about that? Because isn't there this sort of tension between two principles, that judicial independence is also really important? So how do you coax judges back onto the straight and narrow with regard to suppression orders? And also I was just wondering, and you're with friends here, Philip, I'm sure it will be fine to tell us, whether there is any angst or resentment in judicial ranks about their treatment sometimes at the hands of the media, and whether that might be playing into the number of suppression orders we are seeing.
Well, Karen, I think judicial education is critical. Once judicial education was regarded very suspiciously by judges, because they were concerned that rather than education there might be Orwellian re-education. And I think over the years that has passed away. People now acknowledge that work such as by the National Judicial College or the splendid work done by our state college is proper education for judges, controlled by judges, and not programmed by the executive, and not Orwellian re-education. And the Judicial College of Victoria has done very good work on the techniques of suppression orders, including in particular, as Peter has emphasised in speeches, the necessity for sunset clauses. These are basic building blocks in a way, but unfortunately they haven't always been observed. And I think if judges, as they are doing, got those building blocks right, many problems would go away. I think one of the reasons why there are too many orders is that judges rightly are very conscious of the rights of people before them, and are very conscious of the necessity for a fair trial, and are very conscious of, in a well-meaning way, protecting juries. And I think what has happened is that legitimate set of concerns has in turn bred an over-readiness to make suppression orders. I think we need to be tougher than that. I think in a way we need to be more worldly than that. And I think we need to be more confident than that. I've seen juries over more than 20 years, and I've been unfailingly impressed about how careful they are and how hard they work. I think when 12 persons become a jury, they've got as many prejudices. I don't think you've got any prejudices, Karen, but we all, in a way, have prejudices. Your analytical work is fantastic, if I may say, and it's very thoughtful. But when we start out on a jury, like around the dinner table at night or in a hotel or in a coffee lounge, we've all got opinions and we jump to conclusions very quickly. But a jury is a very different entity by the end of a trial than it is at the start. Juries see how hard people work in court. They see how careful we are with evidence. They see apparently plausible witnesses blown out of the water. And I think by the end of a case, a jury is a very different entity to what it is at the start. And I think we should have more confidence in that. And I think the more you see of juries, the more confidence we do have in them. Of course, you can't ask for impossibilities. I understand that. And there are occasions where it is just too much to ask a jury not to be affected by something. But they are very rare. They're not frequent. They shouldn't be regarded as frequent. They're very rare. And they ought to be kept rare. So I think we need all of those psychological sets, if you like, Karen, and I think then we would make less orders. In relation to whether I still use we, although I shouldn't, although we judges sometimes get what you might call a critical press, it's part of the job. It's just part of the job that you get the good and the bad, and I think we know it's part of the job and we just keep moving with it. And I think, although there have been some lapses occasionally, I think generally speaking, the treatment by the media of judges is very good and I think very fair. The main thing I think is not to personalise it. There's been a development recently, which I strongly supported, and that is the naming of judges on the front of judgment so that it's not simply the learned judge below fell into error. Error is a word my wife loves. She tries to bring it into the home. But it's now the judge is named. Now, what has happened is that's in turn, I think, quite understandably, led to a little bit of head counting, and I think that's just part of the nature of the enterprise. But I would encourage people not to personalise it. It's really a systemic question. And it's systemic in the sense that the law is systemic, and the function of the Court of Appeal, which is in part to try and make the law more uniform, so that it's not just a lottery which court door you go in, is all part of it being systemic. So I think keep it unpersonal if you can, but certainly be robust and critical.
Two questions, if I may. Peter Bartlett, both unrelated to suppression orders. The first is, quite a while ago now, we had a Supreme Court judge who was hearing a major criminal case, and it had been going for, I think, about 5 or 6 weeks. And he was just about to send the jury out, and a report was tabled in Parliament. And he took the view that even though the media could publish that report, it could well be prejudicial to his trial. And so at about 8 o'clock at night, he phoned the editor of the Age newspaper and asked the editor, and said to the editor, well, you can publish this report that was tabled in Parliament, but I think it would be prejudicial, and could you hold off until my jury comes back? Which I thought personally was one of the most sensible things I'd heard. I thought it was very unusual, and I'd like your comments on whether there should be, to a greater degree, that open communication between the judiciary and the media in unusual circumstances like that. And the second issue is the Uniform Defamation Act provides trial by jury. So we have trial by jury in every state except the ACT and South Australia. Recently, we've had a Victorian Supreme Court judge, and on a number of occasions a New South Wales Supreme Court judge, basically saying that the defamation law is too complex for a jury, and arguing against the terms of the Uniform Defamation Act. I'd like your comments on that. Thank you.
Well, I'll start with the second point first, Peter. I think it's an unfortunate overreaching by judges to say that things are too complex for juries. It's sometimes said in crime where you've got complex DNA evidence and the like. It's said in defamation, as you say, where it's not the evidence so much as the law that is complex. I think if a judge is competent, the law can be explained clearly. We don't need to be abstruse. We ought to be clear. If the evidence is complex, again, it ought to be explained properly to the jury. So I reject the notion that juries won't understand things. If juries don't understand things, I think the failure is with the court, not with the jury, because I think there has been inadequate explanation, whether it be of the law or of the evidence. So I think the argument is looking the wrong way. On the question of communication, I think one has to be extremely careful of communication out of court. I haven't ever done it in 21 years, and I think it's a hazardous area. I think, however, there ought to be communication in court, and even if that means bringing the parties back to court late at night, which sometimes has happened, and I think in court there ought to be clear communication, even if it's done as a matter of urgency, not waiting till the next day. I think on the more fundamental issue that you've touched upon, Peter, the question of guidance as distinct from orders, in the daily working of the courts, very often judges will, and I think this is highly commendable, say to the media, I won't make an order, but, and then it's said to the media, it's undesirable to publish this, and giving usually a statement of the sub judice principle. Now, I think there's a danger in that I think it can be, although well-meaning, unfair on the media, because what is really unfair on the media is not to have precision in what the court says is acceptable or not. It's very unfair on the media for, in effect, the court to say, you work it out, and if you get it wrong, you'll be in trouble. I think the media deserve better than that. So I think when you are giving an order, you should not only say what can't be published, but you should, in fairness, say what can be published. That's not only fair, it's also productive, because it helps people get it right. I think where you are not making an order, and therefore by definition you don't have the full precision of an order, you ought to be as precise as possible and say, this should not be published, although I won't make an order, but you can publish that. So I think cooperation and decent treatment is very important, but I'm a believer in being in public and open about it.
Cliff Peel, Melbourne Press Club. One of our newspapers, I won't suppress the name, Herald Sun, every now and again comes out with headlines about a paedophiliac who's been convicted, released, and is now in a village, town, whatever, and they want to know who they are so they can warn the local residents, but they can't name them because their name has been suppressed. Now, the person who served his term, his or her term, is out on in the public. Should that name and address be released to the public, the press, or not?
Cliff, it's a very important point that you have identified. As I said before, I think reformation is very important. If people do their time, I mean, going back a step, the old saying is if you do the crime, you do the time. I think that's right. And the second step is, if you've done the time, you ought to be able to move on, talking of an offender. And I think it's very important in terms of reformation that offenders, when they've done their time, are able to move on. And secondly, I think it's right, as a matter of law and as a matter of justice, that when people have done their time, they ought to be able to move on. Now, you may say, Cliff, well, that's fine in the world of theory that judges and academics inhabit, but get real. What about the real street block and the real house, and you've got children next door, and no one knows that there's a pedophile in the house? That is to say, a person who has been convicted of pedophilia and sentenced, for example. I have a lot of sympathy for what you have said or asked, that surely people are entitled to know who is living next door to them. On the other hand, we don't want vigilantism in our community. And I think that we ought to always try and turn our face against the rocks through the window, the paint on the front fence, the shouting as the person walks down the street. So, on balance, even though I have great sympathy with the parent in a house, I'm one of them, I think I'd put my money on not having vigilantism.
Mr. Cummins, James Bennett from the ABC. With regards to with regards to your comments on the robustness of juries and their ability to separate things out, do you still believe that the idea of having a 6-month moratorium on the reporting of co-related trials is a suitable rule for the media to go by?
Well, James, I think you do need a period of time. I don't think it needs to be excessively long. Often the summer break is very good. When you get into February and March, December seems a long time ago. And I've at times listed cases for February when there's a related case in November, and it's 3 months, not 6 months, and I think that's long enough. So I don't think there's sort of any particular number that is really the full criterion. I think you've got to look at the number of months, 6 months perhaps. You've got to look at the period of the time. You've got to look at what else is occurring in the community. And I do think people do put things behind them reasonably quickly. And I think we should have more confidence in people on juries not being unduly affected by what's happened 3, 4, 6, 9, 12 months ago. So I think that's a sensible period of time, but I don't think it's absolute. I think we need to have a break between trials, but I think we've got to be sensible and, dare I say it yet again, robust about it. Now, robust isn't a code word for saying the rights of an accused don't matter. Not at all. I'm strongly in favour of the rights of accused. That's one of the great things about our system, as accused persons get a fair trial, and they should. I think the analytical flaw is that sometimes we've regarded the rights of the accused as binary from the rights of victims, that you can't have both, and therefore you ought to look after the accused and not look after the victims. That is a false division in my view. I strongly think you've got to give accused persons a fair trial. I don't think that means victims need to not be properly treated as well. I think we can do both, and I think we ought to do both. So it's not a question of the one or the other. Undoubtedly, the rights of the accused are non-negotiable. But I think we ought to also give full and proper and supportive care to victims.
Hello, Felicity from Kilvington Grammar. Just a question in terms of the jury selection process. Do you think it's appropriate for the defendant and prosecution to be able to challenge individuals who are in the jury pool before they are on the jury panel, as isn't this reducing the ability of the jury to be a clear cross-section representation of the community?
Well, Felicity, it's a very good and relevant question. Years ago, I changed in my court from having jurors' names read out to having them read out by numbers, juror number 10, juror number 100. And this was permitted under the legislation, but was quite resented by parts of the bar. And indeed, a number of judges also thought it was wrong, because I was told, you're denying the accused the right to know who their judge is. And I said, well, what does it matter if the name of the juror as Ng, or Dostoevsky, or Smith. And I think there is a misconception about the identity of jurors. I think they ought to be all given numbers. And paradoxically, although this wasn't received with any warmth, I think it helps accused people, because there's nothing more dangerous for an accused person than a worried jury. And if a jury is comfortable in court because they've got numbers rather than names, I think that helps the tone and atmosphere of a courtroom, and that in turn helps everyone's rights, including the rights of the accused. So I think that numbers should be given rather than names. And then to answer your question, and I'm sorry for that excursus, Felicity, I, again, will make myself unpopular. I don't think there should be challenges. I think the system is random. Persons are brought up by the computer to the jury pool room randomly. They're citizens, they're in the community. I strongly support the moves to make juries more representative of the community, which both sides of Parliament support, and I do too. And I think that there shouldn't be, Simon, what's the word for selection when you say to the jury, peremptory, thank you, peremptory challenge. I don't think there should be peremptory challenges. That is, challenge because you just don't like the look of them. There should be challenge for cause. That means if there is a genuine cause, such as you know the person or they know you or something like that, that's quite legitimate. But I think peremptory challenges, I think we should abolish them.
Thanks, Philip. Steve Butcher from The Age. I just wonder, sir, whether you could give us some insight into the training or instruction, or how much judges and magistrates receive by way of suppression order applications and the law itself, and when reporters or their lawyers appear in court and so on. Certainly, given that in all of the jurisdictions there are many judges and magistrates who are au fait and quite supportive in terms of applications, being prepared to hear us and our lawyers. But I was just intrigued as to know exactly what may be going on behind the scenes at the college.
Well, Steve, there are two levels of education or instruction. The first is formal and the second is informal. The formal levels are contained in the judicial bench books, the documents which are provided to all judges and magistrates, setting out the methodology of the trial, including suppression orders. And the Judicial College of Victoria does splendid work in producing its bench books, and it's got a very good section on suppression orders. So formally, there is, I think, quite good training in that sense. Don't ever underestimate the informal value of judges' chambers. Simon and I were next to each other for some time in chambers, and you do share a lot of informal discussion, and I think that is a true form of education, and I think is very important. And I think you can go back at lunchtime and have a talk, you can talk overnight. I think that informal culture is very important, and it is a true part of education. So perhaps underlying your question is, why do people get it wrong? Surely it isn't that hard. You are too polite, Steve, to say that. But I think there are some pretty obvious mistakes that I think we've all made, such as not having a sunset clause, as Peter rightly has said in other places. And I think we need to be precise with our orders, and as I've said before, and I've said it often on the bench, we ought to say what can be published, not just what can't, as a matter of fairness and decency to the media. They're really mechanical but very important matters. I think, in fairness to the bench, underlying all of this is a difficult tension between the principle of open justice, which judges not only speak about but act in accordance with, and concern that things don't go wrong, concern for an accused's rights, concern about a jury possibly being influenced, that sort of prophylactic, prudential line of country. And I think that's a real cause of excessive suppression orders. It's not that the judges are not competent, they certainly are. Magistrates and judges are very competent. They've got the proper resources, as I've just said, both formal and informal. But I think underlying it all is that cultural issue of we've got to make sure this doesn't go wrong, got to be fair to the accused, got to be careful about the jury. And I think, of course you must do those things, but I think we ought to have a bit more confidence in ourselves, in the jury, and in human nature.
Steve Lillibune from AAP. You talked a lot about suppression orders and reducing the number. Do you have a line, though, where you think the line should be drawn? Because obviously there's plenty of suppression orders related to, say, instance, some of the gangland incidents, that they all overlap each other. But where would you draw the line, or where do you think the line should be drawn as opposed to where it is now, that you could, taking into account that there are overlapping trials and connected matters like that? And secondly, I just had a question on... you talked about opening up electronic records. What circumstances do you see ever in the future getting a video camera recording a trial and having that accessed publicly?
Well, Steve, on the first point, I think that the line is all contained in that word necessary in the Act, that it is necessary to prohibit the publication. Not that it's perhaps prudent to do so, or that it perhaps is desirable to do so, but that it is necessary. It's a very strict line, and I think we ought to be strict about it and not make suppression orders unless it is necessary. So that's the line there. As some examples of fleshing them out, plainly if a witness is under threat of death, personal safety, issues of that sort, that would be necessary. Where you've got an interconnected trial and a person's going to have an interconnected trial in the close future, that might be necessary. And there are instances in some terrorism trials where courts have been closed, but I think we've been too quick in terrorism cases right round Australia, if not the world, to close the courts down because of the executive's desire to have these trials heard in closed courts. So I think we need to be strict, and necessary is the touchstone. In relation to electronic dissemination of trials, there were a few old arguments against it, and there's been a series of fallback positions. The first one was it would interfere with the courts because you'd have television cameras in courts. Never a good argument. Well, that's now gone because everything's now electronically recorded by the court. The second argument was, well, it would be unduly intrusive because you would focus upon the accused's frowning in the dock or the witness's trembling lip, and that doesn't happen because they're sort of objective courts around the courtroom. They're not focused as in a news item or as in a dramatisation. They're objective camera settings. The next argument was that it will reduce the courts to entertainment. I've always thought that's a condescension by lawyers. I don't think it would reduce courts to entertainment if the thing is done properly and with balance and with fairness, like you get in the print and radio media. And I think the concept that it is reduced to entertainment is partly snobbery and partly because of America, where, as I said, the First and the Sixth Amendments have very different requirements as to open justice, open courts, as they call them, under the Sixth Amendment, than we have here. It's a different culture as well. So I don't think that televising the court proceedings would demean judicial process at all. I think you need to be very careful because it's not just like Parliament, which is now telecast. I mean, politicians stand for office and they stand up in Parliament because they want to be there. Victims don't want to be in court. They don't want to be victims. They're not politicians standing for office. So I think you have to be careful how this develops. and vulnerable witnesses. You've got to be careful how that is handled as well. And as always, you need to be very careful about the rights of the accused. But I think it's a misconception to say that written and radio dissemination is acceptable and visual is not. I don't think the court should be in the business of deciding which one is acceptable. We should have a standard for all, accurate, fair and balanced reporting over all areas. So to take it a bit further, a start would be to televise sentences and judgments. That's a start. Because what you've got there is you've got a controlled environment. The people who are acting on pleas and submissions and sentences are the people who are paid to be there, the judge, counsel, etc. So that's a start. Then I think should consider moving forward towards actually having dissemination of proper trials, and then you would have witnesses who are thereby forced, they're subpoenaed, they're not like politicians in Parliament, but I think that that would be the further step, and we could work through that. So I think it's a progressive thing. And if you look at Jane Carn's work at the Bushfires Royal Commission, I must say I thought that was excellent, and I wasn't on the judging panel, so I can say these things frankly. The judging panel of the Law Foundation had the same view. And you had their witnesses, and some of them under quite severe stress, either because they were having criticism put to them, as we know, and I think more fundamentally because they were under great personal stress. They were suffering from post-traumatic stress disorder, they were suffering emotional overload, and they were filmed, and I think it was done very fairly. So I think it can be done fairly, and I think we ought to step forward and try and do it so that Jeremy Bentham wasn't just writing in 1836, but in 2010 we have what he said we should have.
And one final question from
Justin. Now, I did give you a mention, and
Thank you,
usually
Your Honour.
I'm asking you questions, but it's your turn to ask me.
It is. Thank you, Your Honour, and I should say thank you for your comments today, and I agree with everything you've said, particularly thanks to me. Your Honour, two questions unrelated to each other. The first is really just picking up the televising proceedings issue. Is there anything that the media and the people in this room can do to facilitate that and to actually move that forward and perhaps make it become a reality? And the second question, and I certainly was never able to do this when Your Honour was on the bench, but I'd like to ask a multiple choice question if I could. We saw the numbers of suppression orders and how they, I just noticed I'm putting my hand behind my back like I did when I used to appear before Your Honour. We saw the rise in the number of suppression orders on the table that Your Honour showed earlier. Does Your Honour think that that is due, if you could put blame to a party or a group of people, would Your Honour say that that's likely to be as a result of judges, A, B, the media, C, the barristers who are appearing for the defendants, or D, all of the above? But if Your Honour takes the easy option and D, I'm interested in your views as to how it might be broken up.
Certainly. Well, on the first question, Justin, electronic dissemination, I think the media should keep putting to the courts that we ought to have electronic dissemination, and I think the courts ought to consider that and work on it. So the short answer is keep putting it to the courts, and I hope the courts will progressively move towards it. Courts are certainly moving towards it, but I think we need to move faster and we need to move further than we have. And in particular, I think we need to eliminate what I regard as misconceptions that A, electronic communication is entertainment when it is not, and B, that it's the court's function to decide what is newsworthy, which it is not. That's the first thing. On the A, B, C and D, or meaning all of the above on the blame question, I think you should have asked the category E, namely none of the above. because I think the answer really is none of the above are to blame. We've all played our parts. Defence Counsel, your category C, often make applications. I don't think you can blame them. They're there to look after their clients. They're there to be prudential and to make sure that everything is properly put for their clients. And I think they've got a very important role to play in that regard. So I don't blame them making these applications when they do. Some are well-founded, some are not. But I think they have proper locus to care for the rights of their clients. The media, I certainly don't think the media are at fault. There are occasionally mistakes are made. But I must say in 22 almost years of being on the Supreme Court dealing with a lot of public cases, and I'm pleased to report this, never once has the media let me down. And that's a splendid thing. It's a splendid credit to all of you. And I think we're very fortunate to have you. On the judges, as I said previously, I don't think it's a matter of saying it's the judge's fault. I think the real question is a cultural question. Namely, there's a concern to get it right, to make sure the accused's rights are protected, to be careful about the jury. A very legitimate concern, but I think, as I've said more than once, we ought to be a little bit more confident about those things than we are. And I think underlying it, and I'd like to just perhaps finish on this, I think we should not underestimate the importance of culture. Look at those numbers we put up in Table 1. There's a lot of suppression orders there. And I don't think it's just a matter of number crunching. What happens is with big numbers, culture changes. And what we can do, without realising it, is we can slip from a principle of necessity to a principle of convenience. It's more convenient to do it this way, it's safer, let's not take risks, and we can slide away from the real question, which is, don't do it unless it is, quote, necessary. So I'll leave you with my favourite word.
It was a very uplifting note there at the end to see that the media had never let Philip down. Well, he certainly didn't let us down today. Thank you for an insightful address. Philip was telling me earlier that for most of his professional life he's worked 6 days a week, indeed spending almost every Sunday at the Supreme Court at his desk in his chambers. He also now feels like, in retirement, although given how busy he is, I'm not sure that's an appropriate word, but he now feels like every weekend is a long weekend. He's also looking forward to spending some more time at the track, as he is wont to do during spring carnival times, and we thought it appropriate that perhaps to remember his visit to the Melbourne Press Club, we would present him with this wonderful book that's just been released on the story of the Melbourne Cup to commemorate the 150th running. Philip, thank you very much.
That is splendid. Thank you very much.